on the daily list. Item number 1.
Yes, there are 3 matters. Yes, my lord. The first matter, my lord, in the PIL petitioner is a former MLA, my lord. And what he has alleged in the PIL, my lord, is that there is some figure which is confusing to him. And therefore, he requires this court to intervene in the matter. You will also kindly see page 16 of the PIL. Page 16, paragraph 9, my lord. Paragraph 9. The Secretary to the Mining and Geology Department, Government of Meghalaya, have issued list of quantity of seized coal in district-wise which are to be auctioned, namely East Jaintia Hill District, West Khasi Hill, and so, my lord. It was indicated that 35,201 are still existing remaining in South Garo Hills. It is stated therein that extracted coal mentioned in district-wise of 7th October by the Secretary to the Mining of Geology Department is completely different and not telling with the details of e-auction provided by Coal India Limited, which was enclosed in letter dated 25/9/23 by the Director of Mineral Resources, Meghalaya, Shillong. Whereas, as per detailed lot for e-auction by Coal India Limited, which is enclosed in the letter of 25/9/2023, the extracted coal lying in depot number 10 of Jadikting is only 86 metric ton. But as per district-wise quantity seized coal report dated 7/10 furnished by Secretary and Mining Geology Department, Meghalaya, in respect of South Garo Hill is 35,270. Figure is why, which is confusing and required for spot verification. So the allegation is that the quantity which has been indicated in the auction to the Coal India and the actual coal seized are different, my lord. That's the allegation in the PIL, my lord. Kindly see the credential of the PIL, and I will show the figure also. You also will see page 7, paragraph 1. Page 7, paragraph 1. Paragraph 4, small Roman 1, my lord. Yes. Petitioner number 1 is a former MLA from Rangbara constituency, South Garo Hill district, Meghalaya, and social activities for work and welfare, and owned possessed plot land measuring 15 so million. So he is a former MLA and he is making allegation based on 2 documents, my lord. Kindly see the documents also, which is annexed with the PIL, my lord. And I will show, my lord, how these documents are being doctored and proper report is not being placed, my lord. And it is a case of outrank publicity interest litigation, my lord. Kindly see page 46, Annexure 6. The petitioner has referred to this letter in the petition, my lord. Page 46, Annexure 6, my lord. Yes. Your lordship will notice that 25th September 2023, a letter has been written by Director of Mineral Resources to the Secretary to the Government of India regarding a spot e-auction by Coal India Limited, and requesting you to kindly forward the same to MSTC Limited for further necessary action. If I give my lord short background of the entire matter is that in Meghalaya, my lord, the question arose whether the MMDR Act is applicable or not. The question ultimately was settled by the Supreme Court, my lord, by the judgment in all the Masa, saying that all MMDR Act is applicable, and so therefore whatever mining has to take place, it has to take place as per MMDR Act. So the question arose, what is to be done with the coal which has already been extracted by the miners before 33rd July 2019, my lord. So the Honorable Supreme Court directed that the coal which has already been extracted without following the procedure under MMDR Act will be auctioned by Coal India. Coal India through a process through this. The Supreme Court also said in that judgment, directed that there are 2 sets of coal, one which has been mined prior to 3rd July 2019, which will be auctioned by Coal India through the coal process. And second, after 3rd July, if the coal is found, then the procedure under Section 21 of MMDR Act will be followed, my lord. And then the MMDR Act case will be registered, and after registration of the case, the concerned magistrate will pass the order for auction. So there are two sets of auction which are a procedure which is going on. In the full bench, my lord, Justice Kataki came to be appointed as to monitor all these activities on behalf of the state, my lord. So the reports are being filed by Justice Kataki time to time before your lordship. Now, the first letter is, your lordship have seized 25/9/23 letter, and kindly see case 54. 54. It is the quantity mentioned in Jallikam depot is 86 metric ton, my lord. Your lordship has 86 metric ton, my lord.
This is what is reflected in the affidavit.
Yes, your lordship. And now your lordship will see page 55, the next page. Now, Meghalaya coal e-auction dated 3/11/2023, my lord. And on next page, your lordship will find district-wise quantity of seed coal yet to be auctioned as furnished by Secretary Mining and Geology Department, Government of Meghalaya. Now, you will also will notice South Garo Hill district, where the quantity is mentioned 35,271 metric ton. So what the petitioner is saying, that the coal which is being auctioned is 86, and the other figure which has been given by secretary to whom they have, it is not mentioned. From where this report has come, it is not mentioned. But I have the report, my lord. I will show how he has been manipulating it. Kindly see the averment in this regard, because the lordship will see page 17, my lord. Page 17, paragraph 9, my lord. The Secretary to the Mining and Geology Department, Government of Meghalaya, also have issued list of quantity of seized coal in district-wise, which are to be auctioned, namely...
Where is reading, sir?
I'm sorry, paragraph 9, page 16, my lord.
Oh, yeah, which you have read now.
I have read, my lord, and you also will... The purpose I wanted to show, my lord, for page 17 and last two lines of just above paragraph 10, my lord, what petitioner says, as per district-wise quantity of seized coal report furnished by the Secretary Mining and Geology Department, Government of Meghalaya in respect of South Garo Hill is 35,271.68, which is confusing and requires spot verification, my lord. Now, your lordship, this is a coal which is part of, your lordship will see the report submitted by Justice Kataki before your lordship in 17th interim report, my lord. I have got the report separately, my lord, but the petitioner has not disclosed this fact in the PIL.
Bringing to attention of the court. Be an intervener on state. Can there be a separate public person? These things are single man politics. If he wants, we can be an interviewer. How can another expedition public be fine? Sir, how can? See, already public interest litigation is there. You see, for each and every data, a public interest litigation cannot be filed. If you want, you can go and appear before the subcommittee, single man commission, or whatever terminology is used in the order. You can appear before him and state all those facts, or you can be an intervener. How is this repetition maintainable? Tomorrow some other X will come, your next Y will come, saying that there is another mistake is there, so I must be heard, there should be another public interest litigation. How many public interest litigation on the same issue?
No, here, according to the petitioner, those two deport.
If the report is wrong, as an intervener, you can come and state in the public interest litigation which is already pending. That apart, one-man commission is there. Before the one-man commission, you can place all those details. This is not, we'll give you liberty. We are not going to entertain this petition. Sorry.
Not only that,
Otherwise, everyone, all the lawyers sitting here can file one public interest litigation. That's not permissible.
No, contention of the petitioner is because that I admit, Your Lordship, but however, since there are a number of judgment, number of observations has been made on the other PIL, but there is no respite in the illegal, according to petitioner, those illegal dumping and illegal core mining in the state, particularly in that the allegation, the statement.
See, Mr. Sarma,
Lordship.
what it is saying that
Yes.
you might have a grievance, correct?
Lordship.
Now, single man committee is there. You have a grievance, won't put an application there to examine it. Since he's on the ground, he's doing it, like he's looking it factually on the ground.
Lordship.
And he examines all the parties involved. Not bring another PIL.
PIL is publicity interest litigation, my lord. What before filing the PIL, it is released to the press, my lord.
Mr. Advocate General, this is what we have stated in our earlier order on 5th March 2024.
Yes, lord.
Fifth March, when the matter came up before the division bench,
Yes, ma'am.
we passed an order.
Yes, ma'am. They do not go to any authority. They do not represent anything. They first release in the press and then thereafter they file a PIL on doctoring the document, my lord. I could show all these things. They have doctored the document for the sake of publicity.
No, that regarding the public, regarding the newspaper release, that is not before this court. That is some other issue. It's not before, not about this, not particular about this PIL. It is, he has stated some.
So according to you, the issue is not before the one-man commission.
No, I'm not saying that. Yes,
Okay.
Lordship, I
See,
said
when the
that.
matter came up last time, an objection was raised by the other side, by the state, saying that this is not a public interest litigation. However, he has fairly stated that what we have recorded. The Learned Counsel appealing the respondent would submit that this is not a public interest litigation, rather it can be termed as a private interest litigation by projecting it to expose the cause of public at large and that the maintainability of PA itself is questioned. The Learned Counsel appealing the respondent fairly admitted similar points have been raised with the subject matter already pending before the full bench. So now we are not going to entertain this. If you want, you be an intervener in the existing public interest litigation and make your submission, number one. Number two, as my brother pointed out, whatever objections you have, you place it before the one-man commission. Let the one-man commission take your views and submit a report before us. We will consider.
Lordship, that observation may be made in that order.
Yes, we will do that.
Lordship.
How many cases? What is the other?
My lord, the item. Give me that.
If you want, you do it. We'll say that it's left to you. Suppose your client is not interested, we can't force him to do that. You know, how many cases there are? What is the other matter?
1, my lord, and then 1, 3,
One is 1-3, the other one is
1, 4, my lord. Item
1,
4, 4. Yes,
you are appearing in 1-4.
Oh, yes, Lordship, only in one.
item 1, my lord, item 3, and item 4, my lord. All three are on the same issue only.
Then we'll pass a common order in so far as those matters are concerned,
Yes, please.
giving them liberty to place it before the one-man commission.
May I please, Your Lordship? My lord, I am for item number 3, my lord. Our ground is different, my lord. There was a scam of 37 crores scam by the private respondent number 5 or 6, my lord. The private respondent 14, my lord. And there's our orders, my lord. And we are not that we are before the media or our documents has been fabricated, my lord. My lord, may kindly see the order dated.
So one, we'll first finish this matter.
Well,
First we'll pass orders in this. So PL 13, sir. The petitioner has come forward. So and so prayer. The case of the petitioner is that he was a former MLA. And that in order to bring to the notice of the court about the illegal mining, the present writ petition has been filed. Sir. He has submitted in paragraph number 9 of the affidavit that stated as follows, para number in according to him, in order to ensure that there is no illegal mining, the present writ petition has been filed. Advocate General, appearing for the respondent, would submit that the matter is already pending before the one-man commission and that he is inquiring the same and submitting periodical reports before this court. Full stop. There was also a communication, as has been stated by the petitioner in Annexure 6, with regard to spot e-auction by Coal India Limited. The petitioner has approached this court not by way of public interest litigation, but in his personal interest, which is nothing but a private interest litigation. So, when the matter came up before the division bench, consisting of so and so and so and so, an objection was raised about the maintainability of the PAL, and this court has passed a detailed order on 5/3/2024, which reads as follows. Full stop. When the matter is taken up for hearing, after hearing both sides, this court, we are of the view that in case the petitioner wants to put forth his arguments in the public interest litigation, which is already pending, he has to get himself as an intervener and make his submission, and separate public interest litigation is not maintainable. That apart, the matter is pending before the one-man commission appointed by this court. It is open to him, if he is advised so, to place all the factors before the one-man commission in order to enable the one-man commission to submit a detailed report before this court. Hence, we are of the view that the present PAL is not maintainable and dismissed with the observation mentioned supra.
Item 2, ma'am.
Item number 2.
May it please, Your Honor.
Yes.
Milord, in item 2, Justice Kadaki has submitted a report, 20th interim report. 20th interim report, Milord. And in response to the 20th interim report,
This is the 21st report.
yes, Milord, that is, no, 21st report has not been furnished to us.
Oh.
The, in terms of the last order of your lordship,
Madam, what you do is, all the reports, take a separate Xerox copy and give it to us, the separate file. So it will be easy for us to. Yes. Yes,
Milord,
Advocate General.
20th interim report has been submitted, Milord. In 20th interim report, Milord, certain observations have been made. In response to those observations, Milord, a status report has been filed. Kindly see the status report, Milord.
That is 7th February 2024.
Yes, Milord. This is the interim report is of 7th February 2024. And in response to the interim report, my lord, I have filed on 13th, yesterday, my lord, a status report. A small,
13 March.
yes, my lord. The first issue was before Justice Kataki, my lord, is the transportation of coal from various places to the coal depot, my lord. So there are 4 districts which we are concerned with, my lord. The first is South Garo Hill. In South Garo Hill district, entire coal has been transported, my lord. So there is no issue, my lord. So far as West Khasi Hill district is concerned, my lord, transportation of 10,937 metric remain to be completed, for which transit passes have already been issued to respective coal owners. How transportation could not be completed by owners, citing reasons for remoteness of location, etc., my lord. So we need some more time to ensure that 10,000 metric ton, 10,000 and odd metric ton is transported to the coal depot, my lord. Now the problem which we are facing, my lord, is in particularly this out of, my lord, Southwest Khasi Hill district, my lord, the total re-inventorized coal was 289,662 metric ton, out of which 34,000 metric ton is to be transported. Transit passes are yet to be issued by the owners for reasons lack of adequate space in depot, because all those coal has to be transported to the depot, my lord, and the depot is full because coal has been auctioned by the Coal India, and then the coal has to be lifted by the auction purchaser. So therefore, for 34,000 also we are seeking some time. The problem which we are facing, my lord, with regard to East Jaintia Hill, my lord, last time the order was passed by this honorable court that if the coal owners are not approaching the state government for issuance of transit pass and they are not taking the coal from the various illegally mined coal, my lord, to the Coal India depot, then the state may take over and state may take the entire coal, my lord. That is the direction pass. My lord, kindly see there is some incongruity with regard to this issue, my lord. Kindly see all the Masa judgment, my lord, that is the judgment of this Honorable Supreme Court, my lord. And that's... Give me the last one.
Yes.
Your Lordship, kindly see the directions issued by the Honorable Supreme Court at page 274, my lord, paragraph 195.
274.
274, my lord, paragraph 195, the list of directions start, my lord. And the direction which we are concerned with, my lord, 195.20, my lord, at page 277. Foot of the page, my lord, 195.20 of page 277. The coal extracted and lying in open after 5/15 May 2016 does not automatically waste in the state of Meghalaya, and the owner of the coal or the person who has mined the coal shall have the proprietary right in the mineral which shall not be lost. Then, my lord, kindly see 195.23. It is for Coal India to decide as to when, where they shall receive the coal, either at any of the depot or any place in the state of Meghalaya, and it is for Coal India to finalize the process of disposal and auction of coal. It shall be the duty of the state of Meghalaya and its officer, especially Deputy Commissioner of the area concerned, to enter details of quantity of coal, name of the owner, place where it is collected. All concerned shall take steps to ensure weighment of coal when it is received by Coal India. The expense for transportation shall be borne by State of Meghalaya, Coal India, or by both, which expenses shall be deductible from the price received of the coal. State of Meghalaya shall be entitled to royalty and payment towards MEPRF fund, as well as taxes out of the price of the coal. After deducting its expenses for transportation with 10% of price of the coal, Coal India shall remit the balance amount to the state, and it is for the state, after deducting the royalty and payment of MEPR fund, taxes to pay back the balance amount to the owner. The coal which has been seized by state in illegal transportation and illegal mining, for which different cases have been registered by the state, is not to be dealt with the directed above. The seized coal shall be dealt by the state in accordance with Section 21 of 1957 Act. On being satisfied, the state can make decision to recover entire quantity of coal so illegally raised, my lord. So this 1,36,000, my lord, in East Jantia Hill, 1,34,608, my lord. Kindly see my report now, page 4. Yes. Because this coal, my lord, the coal owners are not coming forward to transport the coal, my lord. That is the problem which this court directed that if they are not coming forward and not collecting the transit pass for transportation of coal to the Coal India depot, state will seize the coal and will appropriate the entire amount, my lord. That is the direction issued by this Honorable Court, my lord. Whereas the direction by the Honorable Supreme Court says that we will...
No, where is it? The entire amount can be appropriated.
Your Lordship, kindly see the order of 9 February, my lord.
9
February 2024, my lord. And the relevant paragraph is, my lord.
9th February.
9 February 2024, my lord. Paragraph 2, my lord. Paragraph 2 of the 9 February order, my lord. 9 February. A point of concern is, however, with regard to the status report of East Jantia Hill district, wherein it has been indicated that out of quantity of 10,04,587 metric ton of re-inventorized coal, approximately 8.54 metric ton of coal transit passes have been issued for transportation from Pithead to Coal India Limited to designated depot. For remaining quantity, approximately 1.5 lakh metric ton transit passes are yet to be issued in spite of availability of space and depot in the district. For reasons that coal owners are not approaching the office of Deputy Commissioner for applying of transit passes in spite of public notices which have been issued. In this view of the matter, to expedite the auction of inventorized coal, it is directed that remaining 1.5 metric tons should be transported to designated depot within this month, failing which the coal will be seized and taken into custody by state government and auction of 1 month thereafter by Coal India Limited. Sale proceeds of such seized coal shall be entirely deposited into the government fund after payment of Coal India Limited for auction and levy as applicable to Meghalaya Environment Protection and Restoration Fund. To this effect, this notice shall be published by the concerned authority and widely circulated, my lord. We have published the notices, my lord, pursuant to this order, but the coal miners or the coal owners, my lord, they have approached and they said that there are some difficulties which they are facing, because what they say that the prices have come down, etc., my lord, and because of that they are reluctant. What I was praying that if one more month is given, if they do not come forward, then we will take a step, my lord, to
You take the coal, we can keep it in some place.
Yes,
then levy them demurrage charges.
yes, my lord.
Only then they will come.
We can do that also, my lord.
That's one way of doing it, because you will be having some storage place where you will be paying rent, or even if it is owned, it should
We'll bear the cost of transportation from the various places to the coal depot. That cost will also be borne by us.
Yes.
Yes.
You bear the cost of transportation,
Yes, ma'am.
and also storage.
Yes,
If
ma'am.
they don't come, then you auction it.
Yes, my lord. One thing is that this quantity is about 1,34,608 metric ton. My lord, the quantity is huge. We need some more time because at least one truck will be carrying 20 ton of coal, my lord. For transporting 1,34,600, we need a large number of trucks, etc. So we need some more time, my lord.
Some more means?
This 1 lakh, at least, my lord.
You're asking for 30 days time.
30 days.
31 days time.
31 days, my lord, I will come back.
Some more means what?
Because the other issue which we are facing is that the election is also round the corner, my lord. Any day model code of conduct will be announced.
For transporting and all, model code is not going to
Because we'll have to issue tender tender to transport it, because we cannot requisition the truck on our own. And when the number of trucks are huge, my lord, here, because if anything which is beyond 50,000, we have to go through the public notice only. So there, the process will have to be followed for this. Otherwise, if the miners would have been coming to us, they would have been getting transit pass and they would have been transporting the coal, we would not have been facing any difficulty. So these are some of the difficulties which we are having, my lord. We have placed whatever time the lordship will give, we'll try to comply the order within that time. Because we have to issue public notice for...
Once the model code of conduct comes,
Yes, my lord.
then it will take at least 2 to 3 months.
No, what we can do is, my lord, we can issue the public notice asking the transporters to give their vehicles. Within 15 days, we will finalize the tender, and then thereafter we will, because that may not be, I discussed with Deputy Commissioner, that may not strictly come within the ambit of model code of conduct, because we are not,
Yes, exactly.
that we are not doing anything which has something to do with
See,
the...
now, whatever it is there in one place, you are taking it and storing it in another place. That is
The
all.
only thing is that we will recover the charges, the demurrage charges, transportation charges after auction. The coal owner will not be entitled to.
Yes.
Yes, to that extent, if the order is passed, we will take a step in that.
Then in the process, they will not pay you more for the storage.
Yes, my lord. That is, and we have got a space, storage space in the coal depot, my lord. We have got now space, because this is the district where the quantity was used. It was in excess of 10 lakh metric ton. And this is the district where we are facing maximum problem also.
See, what we are thinking is that there is no possibility of further mining. See, once you shift all the mines that are lying, the coal that are there lying,
Yes, my lord.
then further
No, that direction is also-
mining may not be possible.
Yes, my lord. And that is the reason for which Lordship has passed the order. That is the reason for which this order has been passed. Because once the entire coal is transported, and for that reason
From
also...
the submission made by you, it appears that as long as the coal is there,
Yes,
it
there
is
will
for
be-
them easy for them to make some more illegal
Mixing is
mining.
possible, mixing is possible. They can pretend that those are the possibilities. So then, if the entire coal is transported, then slate will be blank. There will be nothing, and whatever coal we find,
Subject to correction, I don't know that whether this code of conduct is going to have any bearing on this of shifting of coal from one place to another.
in my opinion, my lord, in my submission, it may not have. It may not have, because we will come out with a tender process where we are, and that too pursuant to the order of this honorable
Exactly.
court. So therefore, it may not have bearing, because we are not giving benefit to any section of the society or any citizen who will be benefiting. And ultimately, if the coal is transported and auctioned, the coal miner will get benefit at our cost, my lord. And then thereafter, my lord, if this is one part, Justice Kadaki has thereafter directed, my lord, that because all those are reports are being regularly submitted. This report is also being regularly submitted and apprised to Justice Kadaki, my lord. Justice Kadaki has also asked for conducting the drone survey of the entire area. Once the coal is transported to the coal depot, so then any coal is found outside the coal depot will be illegal coal, and Section 21 measures will be taken.
Yes, in terms of the orders of the Supreme Court.
Yes, my lord. So, and thereafter, because this is a regular process which will go on, my lord. Section 21 MMDR Act says that whenever we find illegal coal or illegal mineral, they will be seized, criminal case will be registered, and then process in accordance with law will take place. For that purpose, my lord, Justice Kadaki at page 8 of my report, my lord. Justice Kadaki has recommended drone survey and videography of the 4 coal-bearing districts after completion of transportation and auction of inventorized coal, my lord. So this we have also, because there is an oversight committee, my lord, constituted by National Green Tribunal after the judgment of all the Masa, my lord, because Justice Kadaki tendered his resignation And then thereafter, the NGT constituted oversight committee consisting of the additional secretary to the Government of India, Ministry of Environment and Forest, MOE, to monitor all these activities, my lord. So the MER, Meghalaya Environment Restoration Fund, the in charge is that committee, my lord. We have approached the committee for sanction of the fund so that we can carry out the drone survey, my lord. Then there are certain recommendations, my lord. Second is with regard to there was a one-way bridge set up in the East Gentia Hills. That was direction was passed to close down. We have closed down, my lord. There was also a direction to closure of illegal 19 coke oven plants that have already been done, my lord. And there is. Then fourth direction was for realization of.
But you know, these are all not required now.
Not
See, now
required.
we'll say that the coal as they're lying there, it has got to be shifted.
Yes, my lord.
And kept in a storage.
Yes, my lord.
Where the owners will have to pay demurrage charges.
Yes, my lord.
We'll say that. And the pursuant to order of this court, time has been granted. The owners have not cooperated. Publication has already been made.
Yes, my lord.
And that they want time because according to them, the coal price is going down.
Yes, my lord.
That cannot be a ground.
That cannot be ground. That cannot be ground.
So we'll give you further time
Yes, my lord.
for you to shift.
Grateful, my lord.
How many days you require?
At least 45 days because we have to tender the invite the tender, etc. Because only for one district, my lord, so far as other districts will be concerned.
Yes. Yes. So remuneration to the one-man commission is also there.
Yes, my lord. Whatever lordship is to directly.
Yes. This court has passed an order on 9/2/2024 for the purpose of shifting the coal mined on that the coal owners shall participate to ensure that the coal is transported to the transit place and that the deputy commissioner or other authorities concerned shall give a necessary transit pass. In the order, it has been recorded that the coal owners did not evince any interest in getting the transit passes in spite of public notices have been issued. Full stop. According to the Advocate General, the Apex Court, in the decision reported in 1999 so and so, has held in paragraph 195.20 that the coal extracted or mined will belong to the person concerned and the property right in the mineral shall not be lost. He also drew the attention of this court to paragraph 195.23 to 195.25 and stated that the state of Meghalaya and Coal India or both shall ensure transportation of the minerals and the charges shall be borne by either of them or by both. And that coal which has been seized by the state in illegal transportation and illegal mining, for which different cases have been registered by the state, has not been dealt with by the apex court in the decision. It is further made clear the state of Meghalaya shall be entitled to royalty and payment towards Meghalaya Environmental Protection
Restoration.
and Restoration Fund. Is it not?
Yes, Madam.
That is MEPR. And taxes to pay back the balance amount to the owner. Full stop. When publication has been made, it is stated by the Advocate General that the owners have approached the state and submitted that the price of the coal has come down and that they will not be in a position to shift the minerals as it is going to be a loss to them. Full stop. Justice Kadaki, since retired, has submitted a 20th interim report and made certain recommendation, including use of drone technology and the like. It has been pointed out that some of the also has also been closed. Coke oven plants have already been closed. Since the apex court has already held that the mines, the coal, belong to the owners and they have got the proprietary right, it does not mean that the coal shall be allowed to lie in the same place. By allowing that, there is a possibility of further illegal mining by keeping those mines in that place. Hence, we are of the view that the entire mining, coal which is available in the land has got to be shifted or transmitted to a place and it shall be kept in a cold storage, kept in a storage. For the transportation and also for storage, charges can be recovered from the owners. For keeping the coal in a particular place, the necessary demerit charges can also be levied to be collected from the owners. Once the coal is transported by usage of drone technology as suggested by Justice Kadaki, the entire area can be in surveillance and any coal that is going to appear in the land surface can be taken as an illegal mine, and in terms of section 21 of
The MMDR Act. Madam.
MMDR Act, necessary action can be taken. MMDR Act 1957,
Thank you.
necessary action can be taken. Full stop.
is Mines and Mineral Development and Regulation Act 1960.
Yes. Advocate General requested 45 days time for shifting of the minerals that is lying. In view of the submission, the time is granted for shifting the minerals, and it is open to the state to use the latest technology like drone for the purpose of proper surveillance in order to avoid further illegal mining. Full stop. The Justice Kadaki has submitted another report dated 12/3/2024, which is a 21st interim report. Registry is directed to furnish a copy of the report to the parties concerned, and the parties are expected to make their objections or statements based on the report. Also, initial remuneration of ₹3 lakhs to be paid to Justice Kadaki, which is very exclusive of the expenses that may be incurred by him.
Yes, madam. Further remuneration because
Further remuneration. Since we have stated that. Post, sir, post after 45 days. 45, you want 45 days. அதுக்கப்புறம் ஒரு 45 days means you post after 50 days. Now we are on 14th of May, March. 14th of March, whole of March, April. You post it during first week of May.
first week of May.
1st of May.
First.
1st of May. Yes.
Item number 3.
Yes.
May I please about? Well, our matter is a bit slightly different than the other two matters, my lord. Here, my lord, according to the petitioner,
Other two matters means?
the other two.
1 and 2.
1 and 2, my lord.
What about you are 3?
I am 3.
What about 4?
4, my lord.
In my submission, my lord, 3 and 4 all are arising out of illegal coal mining only.
No.
No difference, my
No,
lord.
no, no.
There is no difference.
Okay, let me finish my submission.
Wait, what about 4?
4 is also, my lord.
Yes, my lord.
Coal and coal. 4, your lordship may take up the 4 first and then it can be disposed of. 4. I have
1 and 4 are identical.
1 and 4 are identical, my lord.
No, my lord.
4, who is it? 4,
Yes, sir.
Mr. Sharma.
No, my lords. No.
4 is not.
These are not identical, my lords.
Okay.
How do you say not identical? So this is not
Lord.
15.
Yes, my lord. This is
This is the
the
diamond one.
no, no, my lord. This is not a diamond one, my lords. But there is a possibility that, my lords, we have filed an affidavit, my lords, in which we have duly proved that the numbers of the trucks which has been given by the respondent number 11 are not came to Meghalaya, my lords. It is a report of a GST department, my lords, not ours. We have taken it in a RTI, my lords.
What I tell you? You can't have entry model in these two cases. You let them also appear. What here? So, both of them can appear before Gadaki and submit the submission. See, why don't you book item number 3 and 4? Both of you, why don't you appear before Justice Kadaki and make your submission?
No, my lord.
We are not going to close the matter.
My lord.
We'll hear it so that we'll get the report, detailed report, factual report, we'll get it.
My lord, may kindly produce the order of this honorable court on 11/4/2023, my lord. My lord, may kindly produce the report, my lord.
In PL8.
In PIL 8, my lord.
Yes.
Yes, order dated 11/4/2023 of this honorable court, my lord.
11/4?
11/4/2023. It is a 10-page order, my lord. Details has been given. What was our
1 minute, sir, 1 minute. 4/8/2022.
11/4/2023.
After hearing the latest, yeah. But after this, number of orders have been passed.
11/4/2023, yes, sir.
Yes, my lord. My lord, may kindly produce this order.
We'll have to hear along with this. You have to hear along with it. Okay. Yes, that's right.
My lord, this petitioner, if I may submit, my lord, the petitioner is, if I can show this is a dispute between petitioner, item number 3. This is a dispute between petitioner and private respondent number 14, my lord. Kindly see the nature of allegation, my lord. 14, my lord, is JAMA Coal Private Limited, my lord. Kindly see the memo parties in the PIL. The allegation in the PIL is, my lord, that page 14 of the PIL 8 of 2022, my lord.
Oh, we'll do one thing. We'll have this matter next week and read and come. That's better. So we'll have these two matters.
Yes, my lord.
1 week after, I will read and come.
My lord.
Your lord, may have it up in the first week of April, my lord. First April.
Yes, any date.
Yes.
I'll read and come. So it will be easy
My
for
lord,
me
if I can assist my lord, if my lord produce the order dated 11/4/2023, 17/5/2023, 1/6/2023.
I place all the orders, my lord.
all the orders.
All of orders, your lord.
I'll read all the orders.
All the orders.
Except the adjourned one, I'll read
In
everything.
case here in item 3 and 4, both, my lord, one party, in fourth, the person is saying,
So according to you, it's a private dispute.
it's a private dispute and relating to coal issue only.
Once you started, we
My lord,
But anyhow, there's so many orders are passed.
Yes, my lord. Lordship can have it.
I'll read the entire paper and then come.
After 2 years, they are realizing it is a private interest
And
litigation.
it is always private, it always stated, and I can have realization at any point of
Since my
time.
lord is senior stretching the matter.
Sometimes when bench change, the lawyers also take a different stand.
Yes, my lord. Yes, my lord. Correct, my lord. Yeah, my lord. If my lord is senior stretching, my lord, then I also like to point out one thing, my lord. In the Somoto, there was an order of this honorable court.
Ultimately.
Transfer the SP.
But anyway, we'll read and come. You reserve your argument. You reserve your argument.
My lord.
yes,
When you want.
First of
please, my lord.
First April, your lordship. April's full day, at least somebody will be trying to.
1st April, my lord.
Monday.
1st April, after reopening. Yes.
So 1st April is holiday again, my lord.
No, 1st April we are working.
First April is working. Working. First April is
We have declared the holy holidays. Whole of last week is a holiday. So we are reopening. So first holiday has been shifted to 28th of March.
Yes, 28th of March. Yes.
So first is a working day.
We are grateful, my lord. At least we have got the entire set of, because break one day, break one day.
We can take out our color also, my lord, after playing Holi on the next day, my lord. Hello.
Highly advised, my lord.
When do you want, sir? First.
First. Item 3 and 4, my lord.
3 and 4 on first.
Hello.
Highly advised, my lord. Highly advised.
Yes.
What do you do? You just put surrender and college teachers.
For the list, item number 1.
My lord, in this matter, district council has filed the affidavit. I've gone through. My lord, from my side, it is not required to file a rejoinder. However, the state government is yet to file an affidavit. So whether the state is willing to file affidavit, if not, lord should be proceed for hearing.
So far, my lord, I have not received any clear instructions, my lord. My lord, so far I have not received any clear instructions, my lord. So one time, my lord, I'll pray for some time, my lord. The request of the state for filing objections, if any, my lord. Post after holy holidays.
Yes. How late?
Post after 2 weeks. Only 1 month.
From supplementary list, item number 1.
How many days do you?
4 days. Item 2 is 4 days.
Item 1.
Item 2 is 4 days. Item 1 is.
Millards, these are two appeals. Item number 1 and 2, Millards, these are two appeals concerning, Millards, the release of pensionary benefits.
Supplement list. Yes.
Millards, these are release of pensionary benefits to the members of district council. In item number 2, Millards, there is a delay of 4 days. Item number 1, of course, there is no delay, Millards.
Who is on the other side?
I'm here for KHDC launch. Khasiat's Autonomous District Council. I'm representing.
Oh, that's right. How many respondents are here?
Millards, it's all district council only, Millards, 4 respondents.
Oh, you are taking notice for all the respondents.
Yes, Your Lordship.
What about 4 days delay?
No issue, Your Lordship.
No issue. Yes. Delay condoned. Both are connected.
Both are connected, Millards.
Yes. Delay condoned. 4 days, respondent have no objection, delay will condone. Registry is directed to number the appeal. And listed for hearing along with writ appeal 12 of 2024. In the second week of April.
Second,
That's your Lordship.
In the meantime, if you have any objection, you can file.
Millards, obliged.
From the daily list, item number 1. Item number 2.
My Lordship, here is a paperwork preparation is going on. So if Lordship accommodate me, ask 3 weeks.
Paper book, no.
Yes.
Paper book, yes.
I don't-
The POCSO.
Yes. This is 302. 302, ma'am. 302, ma'am.
30.
Right. Obliged.
Much obliged, Lordship.
Item number 3.
This matter is before this Honorable Court on remand from the Supreme Court, Honorable Supreme Court, my lord.
Matter is pending before Supreme Court.
No, my lord, it is on remand. It has come back on remand from the Honorable Supreme Court. My lord, briefly stated, my lord, what has happened is that Meghalaya College Teacher Association, they had filed 2 writ petitions, one asking for the implementation of the CPF Act and one asking for the implementation of the EPF Act for 2 different categories of teachers.
One for the implementation of EPF Act.
EPF, because those teachers in the second writ petition, which is now pending before the Honorable Court, they were held not to be entitled to the benefits of the CPF scheme of the state of Meghalaya, my lord.
So then they say they will be entitled to the benefit of
EPF. If it is not the CPF, then we will be entitled to the benefit of EPF. Now, both these matters were taken up by the Honorable Division Bench of this Honorable Court at an earlier point of time, and they were disposed of by a common order, holding that all the teachers would be entitled for pension. The matter was taken up to the Supreme Court by the state of Meghalaya, and there was an order of remand back, holding that the division bench here would only address the issue as to the non-implementation of the CPF scheme in the state of Meghalaya. But the other writ petition where we had paid only for the implementation of the CPF matter, that has been disposed of by this Honorable Court when the state considered that all the provisions will be now implemented. This matter, my lord, remains because here the original prayer was for implementation of either the CPF, in its absence, the implementation of the EPF.
so alternate prayer.
Alternate prayer. Now, my lord, when the matter was remanded back from the Honorable Supreme Court, only the prayer regarding the CPF was required to be taken into consideration in an amended writ petition if we so filed one. So we filed an amended writ petition. Now the state has an objection, my lord, that when the remand is only for the implementation of the CPF Act, the writ petition in the present form cannot survive. And if required, we have to come up with a prayer for EPF. That was an alternate prayer which we had also made in the writ petition. Learned AG has objected to it, saying that no, only the CPF matter can be examined in the present writ petition. Now the EPF department has filed an affidavit. If I may draw Lordship's attention to that part of the affidavit, my lord. This was filed on 26th of January. One paragraph which says,
Once CPF is not there, CPA is not there, EPF automatically come into play.
Will come into play.
Yes.
Is under the EPF Act, establishment is covered, then EPF Act will apply, my lord.
Yes, it's
And if you lordship kindly see.
because it is an establishment, is it not?
my lord, it is. The Honorable Supreme Court in the September 2023 has also held that education institutions
Are covered
will be
under the
covered.
EPF Act, my lord.
Yes.
They will apply, statutory provisions will apply, my lord. If you lordship will see the order of the Honorable
Then
Supreme Court.
who is appealing for the Provident Fund?
I am appearing, Lordship.
Yes, madam.
Lordship, according to the scheme, the ceiling limit is 15,000. Any amount within the
Which is the 15,000 rupees?
15,000 is the salary ceiling limit.
Oh, yes.
That is the contribution limit.
1 minute. Yes.
So ceiling limit is 15,000. So 15,000, those who are drawing 15,000 ceiling limits, then 12% from the employer, 12% from the employee will be the joint
Yes, it will be
contribution is
remitted to
made
the Provident Fund, yes.
and Provident Fund. And from the employer share is 8 point some percent is there and 3 point some percent is there. So both the 3 point goes to the Provident Fund and 8 point goes to the
Pension fund, yes.
So if some amount goes to the pension fund, then the teachers are benefited for after their service also some amount they can draw as a pension amount.
Correct.
So we have issued numerous notices also to the institutions, and those institutions where the ad hoc teachers are there. This matter is pertaining to ad hoc teachers. So ad hoc Meghalaya College ad hoc teachers. So these matters pertaining to the ad hoc teachers. So those teachers who are those colleges who have ad hoc teachers, they can avail the facility. And we all avail the scheme. We have also issued notice to the government of Meghalaya for the various departments also to bring into
Ambit of EPF.
EPF scheme.
Yes.
So since my learned friend has already mentioned that in the absence of CPF, EPF can be implemented, we have filed that with regard to this only, we have filed one affidavit stating that we are willing to bring them under EPF schemes. Once the colleges, because there are some formalities to sign up, the colleges agrees and we can, we are ready to, we are welcoming.
No. Where is the question of they agree? It is a question of EPF Act automatically applies. If they employ more than 10%, automatically they applies. That is all.
Yes, but they have to give their data to us unless and until they provide us data of the ad hoc teachers and the salary structures and.
Madam, you are entitled to go and have inspection, call for the records. Dawn and dusk you can enter. You have got every right. It is a separate code.
Yes.
The EPF Act.
Yes.
You are entitled to even imprison a person, civil prison. You are entitled to do that.
Yes, Lordship. We have.
The entire thing you can do that.
Yes, Lordship.
Unless they have a separate scheme which is falling under section 16 or 17 of the EPF Act, your EPF Act automatically applies.
Yes, Lordship.
And then the determination of section 7 will have to be done.
Lordship.
Then they will have to pay interest, the 7Q or so, is it not?
Yes, 7Q and 14B comes.
14B, that is with regard to penalty.
Yes. Yes, Lordship. So for 7Q.
Ranging from 7% to 25% or 37% it is there. 32B,
Yes,
32A and 32B.
32A.
32A, yes, 32A and 32B with regard to sick industries.
Lordship.
Yes.
Lordship, if the case is decided, Lordship, then we will be.
Case is already decided, my lord. The act is applicable, my lord. Kindly see the prayer of the
We can
petitioner.
take steps, Lordship, because during the pendency of the case, because there are
Madam, what is there to adjudicate in this writ petition? Nothing is that. EPF Act is automatically applicable. You will have to initiate the steps. How can EPF will keep quiet?
Lordship, in some of the colleges, we have already issued notice. Some of the schools also we have issued notice regarding 7Q. Later, because of the 7Q and 14B, they come up before the Honorable Court because the penalty is charged, the interest is charged, and they are saying that because of the huge amount they cannot pay, and all
Then you arrest them to take them to civil prison.
The prosecution, they have got right to prosecute them.
You take them to civil prison. In Tamil Nadu, Meghler, Kilburn Electrical Limited. He was the first employer to be arrested and taken to civil prison at Trichy. He was there for 7 days.
Lordship.
And it is offence under 406 IPC also. If they take it and they do not deposit it, it is a IPC offence also.
So you got all the powers.
Lordship. Yes, Lordship. We have all the powers, but we have since last few notices we have issued, and we have under 14 under 7Q and 14B we have issued notices. But later when they came up,
But there should be a determination, you know.
Lordship,
Based on the salary records,
Yes.
who is appealing for the school? I mean the college or teacher, whoever it is. Who is representing?
Notices were served, my lord, on all the colleges. That is respondent number 4, respondent number 10. All the colleges were served, my lord. Respondent number 4 to respondent number 10.
Colleges are served, then they don't appear, we'll make them we'll set them ex parte and pass on order, saying that you have to proceed under the EPF Act and bring an issue to a logical conclusion. That is all. That's all you want.
That's earlier, my lord, they have appeared also on 14 December order. I see the appearances of the advocate on behalf of the private respondents also, my lord.
All the colleges responded. One advocate was responding for all the colleges.
See, when was the coverage according to you? But it is a deemed coverage, there is no limitation also like ESA Act, where the limitation is 5 years here. When was the college started?
They are all.
From when they are applying? From?
They are all old colleges here, my lord. They are. And earlier also, if I am not wrong, my lord, direction has been issued because there was some confusion with regard to applicability of EPF Act on them. But that confusion is also clear, my lord. These are statutory provisions which are applicable to all establishment employing more than 10%. And for cooperative society, it is more than 20%.
Yes.
So that issue is, so therefore they have to, because these are the private colleges and the statutory authorities, they have to.
So the government has no role at all.
Lordship.
Government has no role at all. It's a private institution. You are entitled to proceed against them, and they cannot even challenge that by way of a writ petition. If any notice are given, the remedy is only before the tribunal. Under 7I.
Lordship. Yes, the remedy is only with the tribunal.
Lord, so therefore, this writ petition, my lord, kindly see this writ petition can be closed with the direction to the PF authority to take action.
Where is the prayer?
Page 49, your lordship, kindly see the order, my lord, of the Honorable Supreme Court on which, with the basis of which it has been remanded.
Where is the prayer, sir?
Prayer is at page 24, my lord.
24. Oh.
Prayer number 2 was, my lord, for the
Respondent to say comply with the provisions of the Act.
2 is the CPF which we cannot press. 3, 4, 5.
This one.
Page 29. Supreme Court order. 29. 29 is the Supreme Court order. Page 29.
This one.
Very different.
See, insofar as interest they have to pay.
Yes, Lordship.
Because in terms of number of judges of the Supreme Court, interest is necessary. Insofar as damages is concerned,
Yes.
is going to be a problem for them
Yes, Lordship.
because it ranges from 5% to 37% or so in terms of 32A.
5% to 25%.
25%.
Now, according to the after amendment, it is 25% more than 6 months.
Yes. So, how are you going to overcome the? They have to overcome the damages that is going to be levied.
Lordship, the
Because against that order, they'll have to go before the board under 32B,
Lordship, yes, Lordship,
central board.
yes, Lordship,
And central board, if you read 32B also, they say if it is sick.
Lordship, sick.
So by levying penalty, they'll become sick.
They will. It will be huge penalty, Lordship.
Some you'll have to do some via media. It has got to be done.
Lordship, if anything, let it be to particular to this case, Lordship, because otherwise all the colleges and the
No, we are not going to say what kind of damages you can levy or you can give up by damages. We can't say that. It is beyond the scope of the prayer also.
Lordship, yes,
Beyond the scope of... See, now what we think is that if the employer, the private schools are willing to pay the entire principal amount
Lordship,
together with the interest, it can give a quietus too. See, you must understand the damages amount is not going to the employees.
Lordship, yes,
It is kept in a separate fund.
Lordship,
So the interest and the principal compound alone is going to the employees.
yes, Lordship,
And that the portional amount out of the 12%, 8% year, 4%, approximately I'm saying 3 point something. Pension you are going to extract. Provident fund you are going to pay.
yes, Lordship,
My lord, if I
So
can,
the employer is not before this court.
employer is not before this court. They have been made party, my lord, but only one submission, my lord. Page 29, if your lordship see the order of the Honorable Supreme Court.
29,
Page 29 of the writ petition, my lord.
this petition.
This petition, my lord. Now, feeling aggrieved and dissatisfied with the impugned judgment and order dated 1/11/2018 passed by the High Court of Meghalaya at Shillong in 281 and 360, my lord. It's the same petition, my lord. Page 29, 360 of 2017, my lord. And at page 35, direction of the Honorable Supreme Court is there, my lord. Fine.
Amend the writ petition will open the history to file a counter. Specifically clear that the remand only consider the implemented Meghalaya Act 1969 and provident scheme thereunder, and only the High Court on the basis of the pleadings consider the so-and-so frame Meghalaya not complied with so-and-so.
So far as the implementation of Meghalaya Act is concerned, 1969, my lord, we have agreed, and that matter has been 281 has been disposed of, and because
Now we have amended the prayer. Now the scope of extending the EPF Act.
EPF Act, my lord. So therefore, the EPF Act, my lord, is already applicable in accordance with law on the private establishments.
So this is a fit case where a suggestion can be given to the government for fixing the time limitation. Otherwise, it will be very difficult.
Because the government has no role, my lord, so far as the
EPF is.
Not you, not the state government. The central government will have to make necessary amendment. So we cannot also say that the act will need to be amended.
yes, my lord. That is there.
Is it not? No. There's a Lakshman Rekha is there.
Yes, my lord. Our we can't. Their number. My friend was asking other day that what is Lakshman Rekha? So I explained him what is Lakshman Rekha.
The respondents of the various party, they have to set it. But we can say that the EPF authority implement the provisions of the. So we'll say that in terms of the prayer, on terms of the orders of the Supreme Court and amended prayer, we'll say that the EPFO, Employees Fraudulent Organization, shall take steps to ensure that EPF Act is extended to the institutions who are parties before this court. And you follow the due process of law in terms of the provisions of the Act. And try to extend the benefit of the pension, provident fund and pension. So the employer will have to contribute 12%, the employee will have to contribute 20%. See, now it is 15,000.
Lordship.
We do not know.
2000,
previously 6,500 rupees.
6,006.
Prior to that, it was 3,500 rupees.
I remember, my lord, it
2,500
was 6,000, my lord. It was earlier 6,000. I have appeared.
6,500. 6,500. Prior to this, it was 3,500. Prior to that, it was 1,500 or 2,500 rupees.
Yes, my lord.
So if you go back, you know the various amendments.
Lordship.
Apart from that, it is not like ESI Act.
No. Inside.
Even if the employee crosses the 6,500 or 15,500 is deemed to be covered under the
ESI Act.
EPF Act. EPF Act, and you will have to take the contribution.
Yes, Lordship.
And if the employee can pay more contribution, but there is no compulsion on the part of the employer, employer to make that contribution.
Lordship.
So shall we pass orders?
Yes, please.
Their absence. Oh, the respondents also are absent. They have been served. Pursuant to the orders of the Apex Court, dated 24th August 2022. The matter has been the matter has been remanded, and the Apex Court has passed the following order. Para number 12. Insofar as applicability of CPS scheme is concerned, that has attained finality, and that the employees concerned are not entitled to the benefit of CPS scheme. CPS, Contributory Provident Fund Scheme. Now the only issue is with regard to applicability of the EPF Act. Since the educational institution or establishment, more so in the light of the judgment, what is the citation? The recent judgment, the Supreme Court said that it's covered, the education institution is covered.
I'm just providing.
Light of the judgment, so and so. The contesting respondent, being a private institution, are liable to pay the employer and the employee's contribution together with interest. Full stop. You have a EPF Act, you take section 20, scheme 29, or do you have the EPF Act?
Lordship.
EPF Act. No, here it's 7. What is the scheme? If the employer doesn't pay within a period of 3 months, the deduct and remit, it is the duty of the employer to contribute. The scheme, para number 26 or 27 of the scheme. See, 32, it's very clear,
Lordship.
saying that the subsequent month also he cannot recover unless he gets an approval. So, yes. What is that? Of the apex court and so on. So, yes. It is a duty of the employer, the private employees who are parties here, to make the EPF contribution payable to the employer, payable on behalf of the employer and on behalf of the employee, in case the amount is not deducted from the employee's account and contribution is paid to the EPFO. In terms of the judgment, Catherine of judgment of the Supreme Court, interest cannot be waived. However, insofar as the payment of damages is concerned, it is in terms of the provisions of the EPF scheme 1952, and this court is not expressing any opinion on the same. Stop. Since the amended prayer is restricted, that the EPF Act 1952 shall be applicable to the colleges and to the teachers who are employed on ad hoc basis. Teachers of ad hoc grant in aid colleges in the state of Meghalaya. We expect the EPFO to set the ball in motion in terms of the Provident Fund Act 1952 and take appropriate action and bring the issue to the logical end. It is represented by the counsel appearing for the EPFO that notice has already been issued to the colleges and that speedy determination of the amount for contribution payable by the employer-employee together with interest will be determined and intimated to the school board colleges to pay the entire amount. Full stop. Further stated that the damages levied will also be determined based on the provisions of the Act, more so in terms of 32A of the 1952 scheme. EPF, don't put like that. Sir, I have stated briefly, you must say that employees apostrophe Provident Fund Scheme 1952. 32A. See, there is a recent judgment of the Madras High Court, in which I was a party. In a batch of cases, about 100 cases we have disposed of, sitting with Justice Rajashekar, with regard to dealing with 32B and all, how the damages can be reduced.
That they have
Reduce. Ask them to take it out. So recent judgment. This year only, I think probably past,
we'll go through that
or must be the last judgment.
before you.
Madras High Court. Yes.
May I just make one prayer, my lord? At the initial stage of the order, Lordship has said that the teachers would not be entitled to the CPF scheme. Only praise, my lord, if Lordship says as it exists today, tomorrow, my lord, if the government wants to bring them into the CPF scheme, this judgment otherwise would be that.
No, we are concerned only about the matter pending before this court. That's all. Suppose you are going to get better benefits,
My lord.
we are not going to prevent. Nobody is going to prevent you. See, now that you want CPF scheme you wanted,
My lord.
that has been declined by the Supreme Court.
That's not by the Supreme Court. The government says that it will not be because
That is
the
right.
scheme doesn't
Declined by
cover
the
us.
Supreme Court has not accepted your case with regard to CPS.
My lord.
That's all.
I'm obliged.
If they are going to give you better benefit, see now it's very important. Some of the teachers would have retired.
Yes.
You must also ensure that some negotiation take place with regard to giving up of damages.
Yes.
The reason is why we pointed out earlier is damages, not even a single pie from damages is going to come to you.
Not come to us. True. True. That we are,
The purpose will be defeated, and
The college will also be.
all colleges will have to be closed.
we don't want that to happen, my lord. Definitely, I'll advise, my lord, for the negotiation. I'll advise it.
Insofar as interest is concerned, they have to pay.
I'm obliged.
Okay.
Okay. Item number 4.
When do you expect the new code to come? New labor code.
Labor code, my lord, it is pending now.
Pending for 2 years, nearly 2
Pending
years.
for quite some time, my lord. And they wanted to relax some norms which are there, which.
In fact, I was also asked to address on the new code. Virtually, I was addressing. There are certain amendments are required.
Yes, my lord. And then they wanted hire and fire policy also. A kind of, because of certain time closure and all those issues are there which are troubling. The government wanted some industry friendly at the cost of those things are there.
It is got to come.
Yes.
See, I found that the calculation amount was wrongly mentioned in one of the provisions.
Yes, my lord.
I don't remember now.
No,
Similarly, there is no provision for interim orders by the labor court and tribunals, which is already not there.
Yes,
1947 Act, it is not there.
Yes, my lord.
The new Act also, it is not there.
It is not there. We have been arguing. I remember I argued before the tribunal. Once they have the power to pass the final order, that will also include power to pass the interim order.
You can't say that.
That is the only. I remember Justice Sanjay Kishan call was there in Delhi High Court in one of the matter because tribunal was having circuit benches and suddenly they were earlier they were in Delhi and suddenly matter was listed in Jalpaiguri and all those things. Then Justice Sanjay Kishan call said that there should be certainty that at least one place or some place should be notified in advance so that parties can come. So that there are certain directions have been passed when justice.
Definitely, it requires some corrections.
Yes, my lord, that is right.
So it will be very difficult. Otherwise, everybody will be knocking at the doors of the High Court.
Yes, my lord, that is the.
Even for the slightest violation of the provisions of the Act, they come to the court because the court, tribunal, labor court have no powers.
Yes, my lord.
Even the new court.
This should have been. This should have at least some decision by the Supreme Court or by the amendment in law. That is required.
Supreme Court cannot amend the law.
And at times they read down the provisions too. They fill the gaps also below.
In fact, only after Visaka's case, there's some development of law has come.
This act came. Came. POS Act came. There was no POS Act.
All those things can be done.
Yes, my lord.
But you can't say this is the law, this is not correct.
Yes, my lord.
So you correct it. We can't say that. It was the wisdom of the parliament to do that.
Ambit and scope of judicial review is not.
In fact, there's one judgment of the Supreme Court. In fact, we thought of doing it in one other matter. One judgment in 1987, Krishna District Cooperative case. That's reported in label of para number 14, the last paragraph. The Supreme Court says, coming under the Industrial Disputes Act, they say these are all the suggestions we are making for the purpose of amendment. So we can only make suggestions, yes, but we cannot ask them to do it.
Yes, in fact, in Arbitration Act also there were certain suggestions made by Justice Nariman while authoring a judgment. That these are the issues which need to be addressed so that the working of the Act is fine-tuned and those suggestions have been coming time to time. But at times, Your Lordship has seen exercise of power where there are certain gaps, there is no law, and then the law declared by Supreme Court is also, they have done it.
Yes.
May I please, Your Lordship? Well, this is also related to the coal mining. Basically, what is happening, my Lord? People are participating in the tender process, my Lord, of coal auctioning, my Lord. Thereafter, my Lord, they are lifting the coal and they are taking for transportation, my Lord, or exporting the
So
coal.
then we'll hear it along with that matter.
My lord, this is about a weighbridge, my lord, specifically about a weighbridge. They are not maintaining the weighbridge, my lord. My lord, can you see the order?
Sir, we'll hear this matter along with the batch. Full bench.
No, this is not, but
This is same, my lord. If I can show from the prayer itself, if your lordship will see, all these orders are pertaining to same order, complete coal only, my lord. If kindly see the writ petition, my lord. Where is it?
Yes.
The writ petition, my lord, pages after pages.
my lord, this is my case. Let me just open my case. Then my learned senior can.
No, sir, we will hear it along with the full bench. We'll post this matter along with full bench.
On full
Yes,
Post it along with it.
yes, but this is basically on the weighbridge, my lord.
They are all relating to coal only, my lord.
Weighbridge is not maintaining the record, my lord. On that pretext, my lord, the export, the illegal transporter.
It is also pertaining to coal, is it not?
Not exactly for coal, my lord. It's
Not
particularly
exactly,
for the weighbridge, my lord.
If they are, what my friend is not.
Can I finish, please?
Yes, let him state.
My lord, this is the case, my lord, where the petitioner has approached this honorable court, my lord. They have shown, my lord, that the private respondent has obtained auction challan, my lord. He has participated in the auction. Auction was given to him, my lord, and he has transported from East Jaita Hills to South Garo Hills, my lord. It's around 400 kilometers distance, my lord. Now, my lord, the weighbridge in between, my lord. Those weighbridge, when we have filed an RTI, my lord, they say they have no record, my lord. For that, my lord, we are before this honorable court.
This is for what?
Sorry, my lord, I could not follow.
Weighbridge for what?
For checking the weighment of the truck, my lord.
Weighment of
the truck carrying the minerals, my lord.
minerals.
Yes, my lord.
Coal minerals.
Coal or limestone or any minerals, my lord, or maybe boulders also, my lord. They say they specifically in one line, they say they have no
You
record.
file a objection, sir.
I have filed
They have filed an objection, my
I
lord,
will file
on the
reply, my
maintaining
lord. And your lordship, the issue is what my friend is saying, if I am permitted to say, my lord, what my friend is saying that the coal is auctioned and it is transported from one place to the other place, my lord. And therefore, the transportation of coal, there are issues with regard to transportation of coal. The item 3 and 4 before full bench is also dealing with the issue of coal only. What they say that while in transit, there will be mixing of the coal and illegal coal is being mined. This is a case relating to illegal coal mining only, my lord. And if I can show, my lord, this issue.
Sir, what is the harm in hearing this matter along with
Well,
the
my lord, there is no harm. I just pointed out, my lord, it's a weighbridge.
It is represented by by the Advocate General that the issue pertains to coal mining and the matter can be heard along with the other cases pending before the full bench. A counsel appearing for the petition would submit that the weighbridge issue is involved in the present writ petition and it is nothing to do with the coal mining. Exclusively coal mining, full stop. Transportation of minerals like coal, limestone, etc. are transported and there is no proper weighing in the
And there is no record, my lord.
Huh?
There is no record.
And I vehemently,
weighbridge and that there are no records. Full stop. In order to give a quietus to the matter, we are of the view that the matter may be heard along with the other two cases pending before the full bench in order to give a quietus to the matter.
Well,
Same date, sir. Full bench.
well.
Item number 5.
My lord, the issue before this honorable court is, my lord, that respondent number 1 is manufacturing clinker, your lordship. And
Manufacturing?
clinker, it is as a raw material for manufacturing cement, my lord.
Oh.
Respondent number 7 is cement manufacturing plant, your lordship. They are using mining limestone without having, my lord, mining license, your lordship, and using, my lord, illegally mined coal for the purpose of, my lord, mining, your lord, manufacturing, my lord, and availed, my lord, subsidy around 200 crore, your lordship.
Who is appealing?
And this honorable court was pleased to issue notice, my lord. The prayer before this honorable court was made, my lord. 1 month commission has already been constituted by this honorable court. If your lordship permit me, I will, because this issue is not before 1 month commission. I will go before one-man commission, and one-man commission will furnish report before this honorable court, and thereafter your lordship may proceed in the matter.
One-man commission is there.
Milord,
I'm sorry.
Yes, sir. Yes, sir.
please go.
My lord, if your lordship can look into order dated 9th of February 2024.
9th of February 2024.
That's right, my lord.
This is a matter on 14.3 for maintainability.
Yes. My lord, our case is that the writ petition in this PIL is not maintainable at all because it is in violation of the PIL rules framed by the High Court of Meghalaya. We have made a specific awardment in paragraph 4 of our affidavit, and if your lordship permit me, I'll proceed, my lord, to show and establish.
1 minute, sir. You want to go before the one-man commission that's pending?
My lord, and thereafter your lordship may proceed on the basis of the report. So far as my lord, the objection raised by my learned senior your lordship regarding maintainability of PIL your lordship, on the ground that rules have not been.
Where is it pending? Another petition is pending here. PIL.
No, my lord, this PIL, the issue in this PIL is not before one-man commission, your lordship, regarding cement, my lord. Before one-man commission, coal issue is there, my lord. Here, what I am praying before your lordship, that the respondent number 7 is, my lord, mining without having mining license, your lordship, since 2012. And my lord, they have availed subsidy to the amount of rupees, my lord, 200 crores on the basis of, my lord, manufacturing cement and clinker. I have annexed certain documents also against their, my lord, against state reply, my lord, objection. I have filed my rejoinder also. And my lord, so far as maintainability of the writ petition, this PIL is concerned regarding the technicalities not adhering with the rules framed by this honorable court, my lord. Same issue came up before my lord, honorable Jharkhand High Court. Jharkhand High Court, after going into the merit, came to the conclusion that on the basis of technicalities, the writ petition cannot be thrown out. And that matter,
Where is the order?
that I place, my lord. This is the Jharkhand High Court.
What has happened, my lord, in this case, if I summarize, my lord, this person, my lord, this PIL petitioner, my lord, is also a director in the another company in Guwahati, my lord. He files a case, PIL, saying that the mining is, the cement is being manufactured by this company without having proper mining lease, etc. The case of the private respondent is that it has taken permission and it has paid the royalty to the state government, due royalty to the state government, and it has got the sources through which, legal sources, legitimate sources through which it is procuring the clinker, my lord. That is the case, my lord. The RTIs were filed by the petitioner way back in 2015 and 2017. Based on those RTIs, and if a perusal of those RTIs would also reveal that there is nothing in them, he is filing a PIL in 2023 saying that the cement which was manufactured and for which there is a provision under the central government, some subsidy is granted, and therefore this is a huge scam. That is what my friend is alleging in the PIL, my lord. But it is in the interest of a dispute between, my lord, again in all these matters your lordship will find one redeeming feature or one common feature is that now PIL is being filed here one after the other to settle the private score and private matters. If I can show you, lordship,
Whether he has taken license to...
your lordship, he has got the permission, he has got, I have placed everything, I can show from my documents also. The royalty has also been paid to us because your lordship has seen all the Masa judgment of 3rd July 2019, my lord. Things got cleared from 3rd July 2019. The allegations are pertaining to prior to all the Masa judgment, my lord. Before that, but which whosoever has got the permission, my lord, we have collected the royalty. And on limestone, my lord, in Meghalaya, the royalty is more on minor mineral. If it is a major mineral, then the royalty is less, my lord. That is the one thing is there.
Royalty is levied.
Royalty is levied. We have collected the royalty. That is not also disputed, my lord. If I can show, my lord, the case 7.
What is the problem when everything has been paid?
No, my lord. What I am submitting before your lordship, for the purpose of mining, my lord, there has to be mining lease license, your lordship. Other companies have taken, I have annexed list
So
also.
they have not taken mining?
No, my lord.
What do you say to that, sir?
No, what they are saying is, my lord, that for running a cement company, this is a cement company, my lord. What they are saying that for cement company, you need to have mining lease, only then you can establish cement company. Cement company cannot buy the mineral from other mine lease holders, my lord. Cement companies cannot procure the raw material from other mine holders, my lord. That is what my friend is saying.
But how do you say this, sir?
My lord.
It's independent, you know.
My lord, documents, if your lordship will see, my lord.
Mining is independent, and crushing and getting cement is a different independent.
But what they are doing, they are, so far as limestone is concerned, your lordship, mining has been done, your lordship, without having mining license, and they have used explosive. My lord, it is
That's your allegation.
If they can show my
your lordship, you kindly see, my lord,
Mere
my
allegation.
petition, my lord, kindly see. It is there, your
My lord,
lordship.
kindly
And I
hear
will
a
reply also, I will place before your lordship. My lord, may kindly
If your
come.
lordship,
Yes, Mr. Mishra?
my lord, if your lordship hears on the maintainability, what the petitioner is doing will be clear, and how he has concealed the fact that he is director of 4 companies, not one, and he has business interest in Meghalaya. And it's out of that, he has filed this PIL, and it's not maintainable at all. There is a division bench of judgment of division bench of Guwahati High Court that the PIL rules are mandatory, and if they don't follow, it will be dismissed. I have
Where
annexed,
are the rules? Where are the rules?
my lord, I have
my lord, your lordship
I will
will
give the
kindly have this compilation. I have filed a compilation. If your lordship can have it.
Rules, yes, sir. Which page?
My lord, page
My
1.
lord, I am not director, that I have annexed. my lord.
Huh?
Page 1.
What learned senior counsel has submitted, I am director, my lord. I have annexed the
Let me
documents.
let
I
me
am
place
no longer director of any company, my lord. Wrong statement.
let me place the case. Let me place the case. My lord, your lordship will kindly come to page 3. Page 3, my lord.
Yes.
Instruction of filing PIL litigation, public interest litigation. If my lord will kindly come to Rule 10D, a specific amendment in paragraph 3 of the writ petition specifying the class of persons for whose benefit the petition has been filed, as to how such persons are incapable of accessing the court themselves. This is most important. Then my lord will come to 10F, my lord. In specific amendment in paragraph 5 of the writ petition of the background of the petitioner with qualifications so far as it may be material to show the competence of the petitioner to espouse the cause. If the petitioner is an organization, the names and address of the office bearers and the nature of its activity shall also be stated. An averment shall also be made that the petitioner has means to pay the cost, if any, imposed by the court and on undertaking to the court in that respect. Then my lord will kindly come to 10G, my lord. In paragraph 6 of the petition, details of representation made to the authority concerned for remedial action and replies, if any, received thereto shall be set out precisely. Then my lord will come to J, 10J. Averments made in the petition shall be supported by an affidavit verifying by solemn affirmation by the petitioner disclosing the statement which are true to his knowledge and true to his knowledge derived from the information, disclosing the source of information and true to its knowledge derived from the record. Every public interest litigation shall be accompanied by an affidavit as pro forma annexure A annexed to the rules. So it contemplates 2 affidavits, one where the averment will be verified, and the second is statutory requirement of an affidavit to be filed under pro forma A, which is given. Now, my lord, before I take your lordships to my objection, your lordship kindly turn to page 131. 131.
Of the same book.
Of the same book, my lord, I have given everything here.
Yes.
Page 131. This is a division bench judgment comprising of Justice Amitav Roy and Justice Anima Hazarika at page 132. And your lordship, I will straightway take your lordships to page 134. 134.
Yes.
Upon hearing the learned counsel for the parties and on a scrutiny of the writ petition, we are constrained to sustain the preliminary objections based on Rule 10 of the rules. My Lord, Meghalaya and Guwahati have same High Court rules. The rules having been framed by this court in exercise of power by Article 225 of the Constitution of India and in accordance with the order dated 18/1/2010 by the Honorable Apex Court in Civil Appeal number so-and-so State of Arunachal Pradesh versus Balwant Singh Chaufala, laying down the practice and procedure for exercise of the jurisdiction under Article 2226 of the Constitution of India pertaining to a PIL. We are of unhesitant opinion that the same have to be complied with stricto sensu. The language employed in section Rule 10 unambiguously proclaim rigid adherence to the prescriptions thereof. As the instant writ petition does not conform to the enjoinment of Rule 10, we are not inclined to entertain the same. So on this basis only, my Lord, and I will now place, my Lord, what the petitioner has said. I've already placed, my Lord, Rule 10D. Rule 10D
Page 4.
My Lord. Page 3, my Lord, 10D. Yeah, I'll be repeating only. My Lord, in paragraph 3 has two requirements. The petitioner has to specify the class of person for whose benefit the petition has been filed. And the second most important part is explanation as to how such persons cannot access the court themselves. Now, if your lordship will see paragraph 3 of the writ petition of the AIL petition, my lord, 3 at page 6 of the PIL petition, paragraph 3, my lord,
Yes.
para 3. The relevant portion I will refer from page 7. 8 lines from the bottom, 8 line, by the instant petition, if your lordship can kindly see this, mark this. By the instant petition, large number of people of Meghalaya is going to be benefited. Since the persons are not in group and not aware about illegal acted, committed by the cement plant situated in causing destruction of the environment, cheating of thousands of crores of rupees of public exchequer, the petition is filed. The petitioner is filing the instant writ petitions in the larger interest of public. Now, a class of person, I have enclosed the dictionary, my lord. In the dictionary meaning of the class of person will be persons having common characteristics, sharing similar social position, certain economic, political, and cultural, my lord, characteristic. If your lordship will come to page 6, my lord, I have annexed a dictionary. Page 7, if my lord will kindly see, class. Last one, my lord, left-hand column, class. A set or category of people or things having common characteristics. Now, they are avoided saying class. And they have not mentioned why these people themselves cannot come to the court. And your lordships are aware, under the Environment Protection Act 1986, the Government of India has issued a notification prescribing detailed procedures for before granting clearance for setting up of any industry which are polluting in nature. That notification, if your lordship kindly turn to page 8 of my compilation. Page 8. Page 8 of my compilation, my lord.
Page 8.
8.
Same volume.
Same volume, my lord, compilation. Most of the things happen here.
Yeah.
Now, 8, if your lordship will come to second paragraph of 8. Now, therefore, in exercise of power conferred by subsection 1 and clause 5 of subsection 2 of subsection 3 of the Environmental Protection Act 1986, read with clause D of subrule 3 of rule 5 of Environmental Protection Rules 1986, and in supersession of the notification number so-and-so, dated 27 January 1994, except in respect of things done or omitted to be done before such suppressions, the central government hereby directs that on or from the date of its publication, the required construction of new project or activity or expansion or modernization or existing projects or activities listed in the schedule of this notification entailing capacity addition with change in process or technology shall be undertaken in any part of India only after prior environmental clearance from the central government, or as the case may be by the state level environment impact assessment authority duly constituted by the central government under subsection 3 of section 3 of the said act in accordance with the procedure specified herein after. For the relevant purpose, for the purpose of present case, my lord will kindly turn to page 9.
Yes.
Well, page 11, I'm sorry. Your lordship will see stages at clause 7, Miller, of this notification, page 11. Stages in prior environmental clearance process for new project. The environment clearance process for the new project will comprise of maximum 4 stages, all of which may not apply in the particular cases as set forth below of this notification. These 4 stages in sequential orders are, we are concerned with third. Stage 3, public consultation. Public consultation. Then my lord will come to the next page. What is public consultation? Public consultation, your lordship will get at page 12 of the compilation. Public consultation refers to process by which concern of the local affected persons and others who have plausible stake in environment impact of the project or activity are ascertained, with a view to taking into account the material concerned in the priority or activity design as appropriate. The others are not relevant. Then I'll come to 2, Roman 2, Miller. Public consultation shall ordinarily have 2 components comprising a public hearing at site in close proximity, district-wise, to be carried out in the manner prescribed in Appendix 4 for ascertaining concern of the local affected people. My lord will kindly go to page 4 now of the same compilation, page 44. Public hearing shall be arranged in systematic, time-bound, and transparent manner, ensuring widest possible public participation at the project site and its close proximity, district-wise, by the concerned state pollution control board or the Union Territory Pollution Control Committee. My lord will come to 2.3 now, just below. On receive the draft environmental impact assessment report, the above mentioned authorities, except MOE, Ministry of Environment or Forest, shall arrange to widely publicize it within their respective jurisdiction, questioning the interest of persons to send their comments to the concerned regulatory authorities. They shall also make available draft of EI report for the inspection electronically or otherwise to the public during normal office hours, etc., etc. Then the next page, my lord will see notice of public hearing. I just want to show that it was published in all the major newspaper, national. I'll just place it. 3, I'm placing 3.1. Member Secretary of the concerned SP CB and UTPCC shall finalize the date, time of the venue for conduct of public hearing within 7 days of the date of receipt of the draft environment impact assessment report from the project proponent, and advertise the same in one major national daily and one regional vernacular daily. A minimum notice of 30 days shall be provided to the public for furnishing their response. While pursuant to this, a public meeting was held before the clearance was granted, and they have annexed as Annexure 3, page 18 of their PIL, which is not at all legible. We have given a typed copy of that, which my lord will, if you, my lord can take up our affidavit in opposition filed by the respondent number 7 on 8th of December 2023.
November 2023.
My lord, this is my lord, your lordship is on my lord, page 59 is the photocopy, which is little better than what the PIL petitioner has annexed.
Page number 59.
65.
55.
65.
65.
5 of the AO, filed by us, respondent 7. This was filed on 8th
No,
of
after
September.
61, after 64, we have page number 91.
There are two affidavits filed, my lord, one by state and one by the respondent number 7.
Respondent number 7.
And this affidavit of respondent number 7, my lord,
Page 93.
That one is a state, my lord.
This one, no? Internal page. Internal page?
is 93 Annexure M, my lord.
158.
Ours is Annexure E. Annexure E.
Proceedings of the public hearing held on 9th November 2009.
Right, that's right, my lord. Now,
What's
your
the-
lordship, relevant one.
Different pages are there.
Yes. My lord, if your
One is
lordship can come.
mentioned as 65, the other one place is 158. Yes.
I don't know. I'm sorry, my.
No problems.
Well,
The
my lord, I
council
just want to
record
show.
Who
I
is the
just want
council
to
record instructing him?
show the number of people who participated. I just want to show this from here. And with all their comments. If your lordship see the table, which I have at page 66. I'm very sorry, my lord, it should have matched.
It is. Yeah, it is safe. Yeah, it's safe. And it's safe.
Yes.
My lord, just above the table I'm reading, my lord, the chairperson of the committee then invited the public to offer their comments, suggestions, and objections. Then your lordship will see all persons of the society, my lord, the villages, the social organization, the students' union, 46 of them participated. And they have no grievances except the PIL petitioner, who claims to have represented the people of Meghalaya. He is himself from Guwahati. So this is, my lord, can be anything but bona fide.
May I submit, your lordship?
Yes.
Your lordship may kindly. So,
Please wait, Mr. Mishra. We'll ask him. Yes.
so far as the violation of Meghalaya rules are concerned, my lord, paragraph 1, 2, and 3 I have mentioned. My learned senior has read only para 3. Number 2, your lordship may kindly come to page 17 of my PIL, your lordship. Main petition, my lord. PIL filed by the petitioner before this honorable.
17.
17, my lord. Annexure 1.
Yes.
Here, your lordship will see single window approval for setting up industrial unit. It is given to petitioner. Item, your lordship will see cement plant along with captive plant of 10 megawatt, capacity 0.90 million tons per annum.
We asked you one question. First, clarify that, then proceed.
My lord.
It is a cement industry.
My lord.
How do you say that the mineral shall not enter? And once that is entered, it is also a part of mining in which the industry is also party to it. How do you say that?
Because your lordship, page 31, my lord, kindly see. This is the reply given by Ministry of Mines, my lord, Indian Bureau of Mines. And in reply also I will show, my lord, Ministry of Mines.
Where?
And page 31, my lord. And your lordship may kindly see the mining area in block wise mining of limestone, sale, so and so of all above cement companies mentioned in the subject. The extent of mining lease granted for limestone in so and so is enclosed as Annexure 1. Now your lordship will see Annexure 1, page 32. And serial number 2, your lordship will see Amrit Cement, respondent number 7 before your lordship, my lord. So no mining lease was granted, my lord. Number 1. Number 2, your lordship will see reply filed by me, my lord, by the petitioner against the affidavit filed by the respondent. And this has been, my lord, corroborated by Ministry of Mines, page 15 of my reply, your lordship. Affidavit in reply filed on 8th of February, 8-2, against state's reply, your lordship.
Dated?
Dated 8/2/2024. It was filed by petitioner, my lord.
8th February 2024.
24. And action may kindly come to
page number 271.
I think it is running page, that's why it is not. Page 15.
Page number?
Page number 15, Annexure C of my reply, my lord.
1 minute.
Reply 5.
So if you are going to have 2 or 3 pages, how will they follow it?
But the reply which we have filed, page number is 15, my lord. But there, my lord, reply filed by my lord petitioner on 8/2/2020.
271 is dated 8th February 2024. Is it so?
8th February it was filed by petitioner Shailendra Kumar Sharma.
Oh.
Is it? Your lordship is having affidavit filed by Shailendra Kumar Sharma.
Affidavit in reply.
Reply. And I am inviting your lordship to page 15, 15.
15.
Internal page, my Annexure C. I think registry has given another.
Yes, that's what my brother says. Yes. Yes.
Limestone, and my lord, this is the Government of India, Ministry of Mines, and I am taking your lordship to page 16, And at the top, your lordship will see list of cement companies which have been granted license to use limestone in Meghalaya, so and so. And your lordship will see serial number 50, respondent number 7. No license, my lord. The reply given by
non-operational.
Non-operational. Despite that, my lord, Justice Katki, in its, my lord, 5th interim report, that your lordship will find at page 17.
Yes.
Internal page, your lordship may kindly see 58. It is regarding respondent number 7.
Yes.
Has given chart at page 59. Clinker produced 3,07,286 during 14-15, 4,03,205, 15-16, 16-17, total 20,78,700 metric ton clinker have been produced, my lord. And thereafter, observing page 161.
One sixty-one.
No, only 61. 61, my lord.
Oh. Yes.
Para 2.3.7, year-wise gap in the quantity of coal required to produce the reported quantity of clinker, because for producing clinker, coal is also required, and electricity power, so-and-so, and the coal procured by so-and-so from the legal sources during the audit period are as follows. And gap was found, my lord, you also will see at the bottom, 80,400, total 3,06,067 metric ton. They failed to, my lord, legal way from where they have produced. And regarding public, my lord, my learned senior has submitted, my lord, kindly see, when the permission was granted for 10 megawatt and 0.90 million ton per annum, why in public meeting they have stated, page 18 of my PIL, page 18 you will also see.
Going on merit, my lord, I am on the preliminary thing. Because he is saying as if for establishing a cement factory, mining license is sine qua non. That is his argument.
Till 223, my lord, the report given by Ministry of
Repeatedly, we are asking, my lord, for starting industry,
my lord.
A mining license is required.
Required, my lord. That's why they have given to others.
My lord, kindly.
Others they have mining starts. Others they have, my lord.
My friend permits me.
I think both are independent, sir.
So without, my lord, mining license, how they will mine limestone, my lord, is no, and clinker is the.
Please, you must understand one.
My lord.
You are, take for example,
my lord.
You are publishing a book.
My lord.
You are entitled to publish a book.
My lord.
For publishing a book, do you mean to say that you must have a press?
Yeah. My lord, press, it can be outsourced. But they themselves saying, my lord, they have produced it. They are themselves saying because they have used explosive for the purpose of mining. I am not saying, my lord. You have taken explosive license. Let me conclude.
So, my lord, in 2 minutes I will show. Your lordship, kindly see his PIL only. I will read from the PIL only. Nothing beyond PIL. Kindly see his PIL. Now, what is this PIL all about, my lord? I didn't want to say much, but now my friend has started. So, kindly see what he says, my lord. Kindly paragraphs 5, 6, 7. These are the allegations against the PIL. Paragraph 5 at page 8 of PIL, my lord. So, the Learned Senior Counsel, my lord, on 9/11/2009, a public meeting was held at so-and-so place where the company had wrongly placed before public the cement plant which is going to be established having 1.5 million ton per annum in place of 0.9 million ton per annum and 25 megawatt captive power plant in place of 10 megawatt captive plant. So, allegation is that in public hearing, I said that I will have the capacity to produce 1.5 million ton and I will have 10 and 25 megawatt. So in public hearing, I sought permission for higher capacity, my lord. So this is, he says that this is against law and therefore the company should not have sought for higher capacity, my lord. I will read it again. On 9/11/2000, a public meeting was held at so-and-so place where company had wrongly placed before public the cement plant which was going to be established having 1.5 million ton per annum in place of 0.9 million ton per annum and 25 megawatt captive power plant in place of 10 megawatt captive power plant. His case is that single window clearance which was sought by the company from the state government, they said that they will produce 0.9 million ton, my lord, and they will have 10 megawatt captive power plant. In public hearing, when in 2009, your lordship kindly mark, in 2009, when the company went, company said, I will have the permission for higher capacity. So this is violation of public interest because companies should have sought only 0.9 million ton capacity, my lord. This is the first allegation against the company. Why did you go for 1.5 million ton instead of 0.9 million ton? I will answer that also, my lord, that this is the first violation. Second violation, my lord, is that the company has got the license for use of explosive, used for the purposes of mining, my lord. Concerned till today does not have mining license. So why did you procure mining license when you did not have the mining permission? So you can get the explosive license only when you have mining permission. Second allegation, my lord. And third, in the bottom, further the respondent number 3, while later dated 2013, granted consent to operate to respondent number 7. Further, respondent number 7 from 2012 to, your lordship, has manufactured 20 lakh ton clinker. It's nothing to do with mining, and 45 lakh to 50 lakh ton cement in manufacturing clinker. About 10 lakh ton coal have been used, my lord. Now 7. Although from 2012 to 13, kindly mark the period, my lord. Period will be very relevant. 2012-13 to 2016-17, the production of clinker and cement was substantial by respondent, has not made any payment on account of royalty and cess. I have said so. Payment of royalty and cess has been made, my lord. That has been said. And kindly see. Now there are 3 allegations. First allegation is that the company went for higher permission, my lord. Kindly see my reply to this. My counter affidavit, which is filed on, my lord, 30th November 2023.
Shall we continue tomorrow?
Not tomorrow, Monday or not? Monday.
Your lordship, may I have it tomorrow, my lord?
Tomorrow I have some parted matters.
Tuesday.
Wednesday, your lordship, may I have it on Wednesday?
Wednesday.
But we have got a serious doubt about the maintainability of the writ petition.
My lord, I will say.
I have got some authorities also, my lord. This court has also held.
See, this is the only point which we have asked, and thereafter senior advocate Mr. Mishra also posed, and advocate general also asked, when for having an industry, cement industry, do you mean to say that they should also have a coal mine? Or coal license?
For limestone mining, if they are mining, my lord, without mining list, they can't mine. That they have mined.
They are very delegation.
It can also be like a jobbing industry. Somebody can bring it and they are
not saying in PIL, my lord, that this is a cement industry.
Because from outside, my lord, as per their own reply, from outside from cement industry, my lord, limestone is not permissible. They can't buy from outside vendors, your lordship. And that they have to mine. That letter I will place before your lordship.
It is speculation, and it is all laid down by him. That we cannot.
My senior, like Mishra, my lord, told me in my initial stage, when your case is poor, always jump on maintainability. That's why we say that
it's not only maintainability, on merit also we will demonstrate. On merit also we will demonstrate.
That's why, my lord, whatever I learned from my senior, I am not placing before your lordship. My senior is
maintaining the same point.
I will that point, your lordship.
I will show on merit also.
My lord, if your lordship, may I, my lord, if your lordship permit me, I just want to make one submission, my lord.
So we'll hear you in detail on Tuesday.
On maintainability as well as on merit, I'm prepared, my lord.
Yes,
both come.
Both you address.
Yes,
will do.
Yes.
Deeply obliged.
I appeal for response private CBI and Enforcement Directorate, my lord.
There is no occasion of CBI to file affidavit. They have filed affidavit. They are saying, my lord, that we have no manpower. If state government is investigating, they have no problem.
My lord,
what was the necessity?
Right to file? Why has he arrayed me as a party, my lord?
Because I want it should be referred to CBI, my lord.
We'll see.
No, you want to threaten us.
Minister requires to refer to CBI, my lord.
That's a tactic.
This is a case, my lord, where I will satisfy, my lord, how in Meghalaya, my lord, cement industry are availing, my lord, thousands of crore subsidies, my lord.
And my lord,
in several cases, this honorable court has passed a number of orders, my lord.
He is a resident of Guwahati, my lord.
Wednesdays?
Yeah.
On Wednesdays, best match.
23 matters are there, single.
21st also.
Wednesday. List matters. Wednesday.
Obliged.
Wednesday.
My lord, he is a resident of Guwahati, my lord.
There is no bar, my lord.
He is espousing the cause of people in Meghalaya, my lord.
So there is no bar, my lord.
He is a director in 4 companies, my lord. He is a director in 4 companies, my lord. He has a business interest.
He wants to shut down the industry.
They've argued. See, it's a private interest litigation or any interest is there and all those things we can see.
If the state is making wrong, it is taking, my lord, that has to be my state. Also, my lord. Regarding director, I will show, my lord, I am no
business rivalry petitioner and private respondent, my lord. And to settle the interest liability is filed a writ petition, PIL petition, my lord.
And that too, data pertaining to 2009, 13, 15, and he says he was having RTI in 2017. Why did he sit over that RTI application for 6 years, my lord?
If, my lord, some illegal thing has been brought before your dishonorable court, your lordship may take up suo motu also if they have
I will say
That is entirely
If,
different.
my lord, they are doubting my bona fideness. Your lordship may,
See, now convince us on this point
my lord.
that mining license is required for commencing a cement factory, cement industry.
For producing clinker, that is required.
For
Clinker is the, my lord, after clinker cement will be manufactured, my lord.
this is a byproduct.
Byproduct, my lord. So for the purpose of producing clinker, my lord, mining license is required, that I will place, my lord. That's why, my lord, Ministry of Mines also, they have given, these companies they are having mining license.
So they apply, what has happened, my lord, that the companies, what the data my friend is showing, that they applied in RTI that which are the companies which are having mining licenses. So that companies, the data was provided, these companies are having mining licenses. So that, from that he is extrapolating, saying that look, the Amrit Cement is not having mining license. It has nothing, that data is only, they pose the question, how many companies are having mining license? The answer is that these companies are having.
That is right.
That is right.
Now he said for preparing that
yes, my lord.
the product, byproduct.
Yes, my lord. And
You
even
must
in
have
Himachal Pradesh, my lord, in all other places, all other, I have got rules which so that even those who are having the license for mining the minor mineral, they can supply to the cement industries. And they have some, and the case of the private respondent is that we have procured it from and we have received the royalty. But I will show the conduct and all those parts, my lord. I am keeping my power.
There are many, that is so, my lord. Your lordship may take up this matter suo motu, my lord.
My lord, there is on and off man to hear one party at a time.
That's why, my lord,
Then
if you
reading 4 or 5
finds that,
my
my lord, if your lordship finds that there are irregularities,
In this case, certainly your lordship will find.
yes.
On good news.
Of state government and private.
My lord, my friend. He wants that this matter be taken up suo motu and my friend should be
Yes.
On Wednesday, my lord. Deeply obliged.
Check the date, Check the date. Or do you want to do immediately after vacation?
Immediately after vacation, my lord, it will be better, my lord.
Holidays, you check the date and
1st April.
Except 11 to 17
1st April, we can have 1st April. 1st April.
11 to 17, yes.
1st April.
Yes.
Item number 6.
May I please, your lordship? I am appearing on behalf of the respondent to VC, your lordship.
Yes, sir.
May I please, Your Lord. My Lord, this miscellaneous application has been filed seeking condonation of delay of 187 days in preparing the, my Lord, income tax appeal, my Lord. My Lord, we have explained the delay in our paragraph 2 and 3, my Lord. This is, my Lord.
You are for the petition.
I am for the appellant, Lordship.
Petition appellant.
Lordship.
So what is there, sir? Delay.
Yes, your lordship, we are objecting the delay. We have already filed the reply on the last occasion, your lordship. To that reply, they have filed their counter here. We have received it, your lordship. Your lordship, one point we like to highlight that firstly, the delays of 270 days, 270 days, counting from the pronouncement of the impugned ITAT order. As the Orient Builder case, your lordship, we are relying full bench of Delhi High Court have already held that the date of pronouncement of
the period for which the period of limitation prescribed in the Act needs to be excluded. That's what the judgment of the Supreme Court says.
Yes, your lordship, by both of us. Your lordship, 270 days, it comes after excluding 120 days of filing an appeal. After excluding that 120 days period permissible, 270 days it comes.
After excluding the 120 days, 270 days. What do you say to that?
No, my Lord. After the, my Lord, 120 days, there is delay of 187 days, my Lord, Lordship. So we have explained the delay in our paragraph 2.
No, he says it is not to 167 days.
No, my Lord. He has said, my Lord, the delay has to be, my Lord, the limitation has to be counted from the date of the order passed by the Honorable ITAT, my Lord. In fact, your Lordship may...
That is your case.
No, yes, date should be counted from the pronouncement after excluding the limitation period of 120 days of filing an appeal. After excluding that 120 days, your lordship.
After excluding 120 days, how many days are there?
270 days. 270 days delay is there, Your Lordship.
No, my lord,
270. Because my friend is calculating from the date of 31st March. He is saying that the order, impugned order, is being received by the concerned commissioner on 31st March. So that is not the point, Your Lordship. When the court makes a pronouncement in the open court, it is available on that very same day to the DR. On 2nd of January, the date of pronouncement is there. So the learned DR departmental representative was very well aware on that day only the order.
But it is not to be counted from 2-1.
My lord, your lordship may see the section 260A of the Income Tax Act, my lord. I have submitted my short written submission, my lord. I have annexed, my lord. It says, my lord, the principal chief commissioner or the principal commissioner or the commissioner or the associate aggrieved by any order passed by the appellate tribunal may file an appeal to the High Court, and such appeal under this subsection shall be filed within 120 days from the date on which the order appeal against is received by the SSE or the principal chief commissioner or chief commissioner or...
So you received it on
31st March, my lord. So, my
Your
lord...
Lordship,
Yes, sir.
I'm sorry.
You got the 260 capital E.
Am I?
Yes, sir. Yeah, I'm condoning it. We are condoning the delay, sir.
Your Lordship, the Orient Builder full bench decision has already dealt this section, very old section of this received only, Your Lordship. I want to rely on one paragraph of Lordship.
Yes, very well.
Permit me. Lordship, from the Learned Revenue Council submission on page 25 of the Supreme Court decision, Your Lordship.
Page 25.
Yes, this para 29 of the Supreme Court latest order.
So where is it? Where is it?
Learned Council of the Revenue have filed 32-page reply just for explaining the delay, Your Lordship.
32-page reply.
That third judgment of Shivraj Singh versus Union of India, Your Lordship.
Yes.
Your Lordship, para 29, considering the aforementioned decisions, there cannot be any quarrel.
One is advocate for the petitioner.
I'm sorry, Your Lordship.
Yes.
Your Lordship, para 29, I am reading, Your Lordship, with your kind permission. Your Lordship, considering the aforementioned decisions, there cannot be any quarrel that this court has stepped in to ensure that substantive rights of private parties and state are not defeated at the threshold simply due to technical consideration of delay. However, this decision notwithstanding, we reiterate that condonation of delay being a discretionary power available to court.
Yes, this judgment we have already referred to in earlier case. Also,
Your Lordship, but
yes.
But all I want to submit, Your Lordship, is they have given an excuse, not an explanation. In the para 4 of their condonation application, due to their technical hierarchy system, they have just given an excuse. And this date of 31st March, they have not enclosed any evidence of the date of receiving. They have not enclosed any stamp.
My lord, that is the official seal, my lord, above the impugned order, the date of receipt, my lord. Your lordship will find that, lordship, page, my lord, annexure 3 of, my lord, my appeal. Page 48, my lord, that is the receipts, the seal, my lord, of the Office of the Commissioner of Income Tax. That is 31st March. Page 48 of my appeal, my lord.
I'm sorry, Your Lordship, I'm not having that 48 page.
Annexure 3, my lord, that is the impugned order, my lord. That is the official receipt of the, my lord, the Office of the, my lord, the appellant, 31st March. It was received on that day only, lord. My lord, in fact, my lord, we have explained sufficiently in our paragraph 2, my lord. Sometimes, my lord, it happens, my lord, delay.
Then you pay some cost for the delay.
Lordship,
You are charging so many damages, interest, etc. from the SSE. Why don't you pay some cost?
In fact, my lord, we have explained, my lord, in our paragraph 2, my lord.
So you pay some cost to the Shillong Bar Association.
Lordship.
You pay.
Lordship.
On payment of cost.
I'm in your hand, Lordship. I'm in your hand.
Yes. When the petition has come forward, you have to control the delay of so many days. It is submitted that in terms of section 260 capital A of the Income Tax Act, the date of receipt is material to control, to calculate the delay and not on the date of the order copy made ready. For the sake of convenience, 260A is extracted below. Stop. The respondent has opposed the continued delay petition, stating that delay has got to be counted from the date the order copy is made ready and not from the date of the receipt of the order copy by the department. According to the respondent, the delay is not 167 days, it is more than 200 days. Full stop. The petitioner has also relied upon para number so and so.
Para 2 and 3.
25 of the objection submitted by the respondent to contend that there is a difference between explanation and an excuse, and that even if the delay is short and no proper explanation is available, the length of delay is immaterial and the petition has got to be rejected. Full stop. We find, after hearing both parties, we find that the reasons given by the respondent are acceptable, but however, a petitioner acceptable, but however, it cannot be condoned without imposition of cost. Hence, we direct the respondent, petitioner, pay a sum of rupees, pay cost of rupees 10,000 to the Shillong Bar Association within a period of 2 weeks from the date of register of the order, and on production of the receipt of the same, registry is directed to number the appeal and list it for hearing.
Lord, may I pray, Lord, let it be 5,000.
Huh?
Let it be 5,000, Lord, cost.
5,000. You know, see, you are also in this side, bar.
Lord.
We are helping the bar, that's all, association.
Deeply obliged.
Otherwise, it is from one pocket to another pocket only, Lord.
Huh?
Otherwise, it is also bad.
No, the same principle is going to apply to you. When you
Yes,
go to
Lord.
the side.
I bought him, Lord.
I may not remember your name, but I will not forget your face.
And so I'm
Yes,
deeply obliged.
So it will be with interest, more than 10,000 when you appear. Yes.
Oh, deeply good.
Item number 7. From the daily list, item number 1.
Please, Your Lordship. Your Lordship, we have taken steps for the respondent number 6. This is still awaited.
So notice.
We've already taken steps.
1 to 4 we are appearing.
1 to 4. How many respondents are here?
6, Your Lordship. 6, Your Lordship.
5 and 6?
5
I'm
is
appearing for 6, my lord.
You're appearing for?
Number 6.
5?
Number 5. Number 5.
Who is appearing for number 6?
6, we've taken steps, Your Lordship. We've taken steps to issue notice, but it was still awaited. The notice is still awaited.
Await service. Will you take fresh notice?
Lordship, we'll file an affidavit of, we'll get the report from the post office where it is served for now, Your Lordship. File an affidavit to that effect.
Sir?
Lordship, we'll take some report from the post office with regards to the delivery of the notice.
Suppose the person is not traceable, then you will have to effect paper publication.
Lordship, we've taken step only on the last date itself.
The council for the appellant submitted that he'll take steps to ascertain about the service of notice on the 6th respondent and report the same in the next date of hearing. Yes.
Lordship.
Item number 2.
Please, Your Lordship. Lordship, I'm praying for some accommodation.
Accommodation.
Lordship. After vacation, Lordship.
What is the matter about?
Lordship, this is an appeal from the single judge order, Lordship, regarding promotion, Lordship.
With regard to the pay scale, promotion.
Promotion.
On the request of the appellant.
Lordship.
Yes.
From supplementary list.
My lord, if lordship permits, my lord, I beg to make a mention for adjournment, my lord.
Madam?
I beg to make a mention for adjournment of supplementary number 2, my lord. This is a fixed matter, my lord. My lord, the only difficulty is this matter.
Anyway, it reach. Only 2 cases.
My lord, both are for hearing, my lord.
115, you are hungry.
It's for hearing, my lord. Both are listed for hearing, therefore, my lord.
So only 2 cases.
In hearing, my lord.
3 cases. So which item you want?
My lord, number 2. Item number 2, my lord.
MC number, orders.
My lord.
One minute.
It's for hearing, my lord. Supplementary number 2.
1 minute. We don't know. Supplementary list. Where is the supplementary list? Single bench. 1 and this is 1. Hearing. WP 259.
My lord, 556 of 2019, my lord.
Huh? Full bench, division bench, division. 1 minute, where we here, sir, single. Yes. 556
of 2019, my lord.
What is the matter about?
But this is a matter regarding pay, my lord, fixation of pay and pay parity, my lord, for the post of community organizers in the Juwai Municipal Board. The other municipal boards, my lord, all over the state, they're getting a fixed pay. While we, in Juwai, this particular post, this particular person is not getting that.
I appear for the state, my lord.
One time.
My lord, yes, my lord.
Post.
Correspondent number 7, my lord.
Yes. At the request of the respondents,
State respondents, 1 to 6.
For 2019, give preference.
Only for the, because the senior counsel, my lord, learned AAG is not well, my lord. He suddenly falls sick. So this matter can be taken up next week also, my lord. There won't be any difficulty.
Yes. I've already said the absence of senior is good for you to argue.
My lord.
Is any of, yes.
Item number 1.
Which one? 286.
May please, Lordship. Well, this is that matter regarding termination of the service of the petitioner. Your Lordships had heard it. And, my lords, your Lordships had directed by order dated 5/3 that the managing committee of the school be made a party, my lords. Because here, my lords, what has happened is we sought instructions, my lords. There is no existing managing committee of the school.
There is no
managing committee, my lords. The term of the managing committee came to an end in 6/9/23, and my lords, thereafter there is no managing committee as on today. We filed an affidavit to that effect.
Who is representing?
My lords, it's the state which is taking care of the affairs of the school.
Then file an affidavit.
Yes, yes. My lord.
Next hearing will
No, I filed the affidavit already. It's already on record.
When the matter is taken up for hearing, an affidavit dated 14 March 2023 has been filed, stating that there is no managing committee after September
26 September 2023, minutes. Paragraph 4, your Lordships will find it.
After 26 September 2023. Hence, that in view of the same, there is no need for the party to be implemented as party. Pose a matter for hearing.
That's.
This is with regard to?
Well, he was removed from service and the private respondent was appointed as against that post. By the same order without hearing.
In order to accommodate, you said no, he was been working earlier.
Not he is employed.
Yes, I remember this.
Well,
yes.
My case is, well, is that I have been removed without being allowed an opportunity of being heard. That's the only limited issue.
From the daily list, item number 1.
Please have lunchtime.
I would not like to keep your Lordships away for lunch. Well, this matters very limited issue involved. Well, these were home guards who were appointed in the Auditor General's office. Now, well, they had come before this Honorable Court in an earlier round of litigation for seeking regularization. The court said we cannot regularize you, but your services will continue till such time that the department continues to have requirement of home guards in the office to that limited extent, and you will be permitted allowances. Subsequently, my lords, an order was passed where their services were terminated. We came before this Honorable Court. Under interim orders of this Honorable Court, my lords, the matter continued and I superannuated. So it is only a question of the pensionary benefits, my lords, that would have to be decided by your Lordships. What is basically the allowances, my lords? They will not be otherwise entitled to pension, but the allowances would have to be paid. We could have it after a week or 10 days, subject to your Lordship's convenience.
Request of post the matter in April.
Obliged.